5, 4, 3, 2, 1. On going through the records and on hearing the counsel for parties, I am of the view that the complaint has to be quashed on the ground of huge delay which was caused prejudice to the parties. On a similar facts, the Supreme Court had an occasion to consider the above question and held that the complaint is not maintainable when the complaint was filed with a considerable delay so as to deprive the right of the petitioners accused to seek for the report on second analysis. In my view, the finding given in the decision rendered by the Supreme Court reported in A.D. Advani versus State of Maharashtra 1991 FAC 222 is squarely applicable to this case also. The relevant portion of the observation of the Supreme Court is as follows. Rule 9a uses the word immediately replacing the words within 10 days. This expression has to be appreciated in the context of the facts and circumstances of each case, bearing in mind the purpose for furnishing the report. The report is dated 21st September 1977. Yet the filing of the complaint was delayed up to 25th April 1978, but the copy of the report was dispatched on 10th July 1978 and must have been received within a couple of days. Keeping in view the objective of the requirement to furnish a copy of the report to the accused, we think, having regard to the delay which had already taken place, it was incumbent on the part of the local health authority to have promptly sent the copy, which it failed to do. We therefore find it difficult to agree with the line of reasoning adopted by the High Court. We think that the High Court was not justified in interfering with the order of acquittal in the above circumstances. We therefore set aside the conviction recorded by the High Court and restore the order of the trial court. The fine, if paid, shall be refunded. Bail bonds will stand cancelled. The appeal is allowed accordingly. The decision cited by the counsel for the respondent would reveal that in the absence of any application by the accused under section 13(2) of the Act for getting the sample analyzed by the Director Central Food Laboratory, the accused could not complain any prejudice. In some of the decisions referred to above rendered by various high courts, it had been held that Rule 9a of the Act is only directory. But those decisions would not help the respondent in view of the fact that the observation made by the Supreme Court in the case cited supra would support the contention of the counsel for the petitioner in view of the fact that the complaint was filed after 22 months and immediately on service of notice on 24/1987, the petitioners filed an application requesting for second analysis on 21/4/1997, which admittedly has not yet been disposed of.